from. And so if they understand that, oh, if I self-identify, it's not going to be so much, creating problems for me as it is, it's going to allow me to make use of this additional resource, then they might be more likely to take advantage of it. One thing I'll mention here is a common practice, or it's not common yet, but I think it's going to become more common over time. I think it's something that libraries should be starting to think about, though I don't know many are doing it yet, is there's a separate, not similar to captioning, there's something called audio description. Mm-hmm. Some tools allow for both. And what that is it makes video content more accessible to people with visual impairments because it provides a description of anything that's happening on the screen that isn't already reflected through the dialogue or clearly through the sound effects. So it would tell you if someone walks somewhere, or I don't know, if you're watching a soap opera, who slaps who, or something like that. And it's becoming more common. There are tools like Cadet that allow you to create them, and I think it's something that libraries haven't started thinking about a ton yet, but it's worth considering.
Can you spell the name of that book?
Yeah, it's CADET, all caps, and it's through WGBH, and it's totally free to use.
And we're talking about it later.
Oh,
Even
sorry, I didn't mean to steal
Can we
it.
close the ties there?
Clearing it all up.
It's super awesome to hear about that. All right, so now I like this one. We got some opinions on this. In response to an order by the U.S. Department of Justice, University of California, Berkeley is removed 20,000 audio and video files from YouTube, iTunes U, and the university's webcast site. To view or listen to these files, users will be required to sign in with the University of California credentials. Yes. So, question, was this a reasonable decision by the university?
Let me just also add, in response to an order, I mean, it wasn't an order to remove, right? It was an order to,
Make
it was an order that
yes.
the materials were not appropriately
Good
accessible
point.
and, do something about that, right? And so then the response was, Berkeley was thinking about it and then they removed it. They decided to remove it, and they also cited intellectual property reasons.
Well, that's the
Yeah,
worst of all
skirty.
reasons.
Yeah.
So I know Carly has an opinion on this, so I'm going to let her.
So, I used to practice law. I understand what happened here, but I don't know. So UC Berkeley used to be known as sort of like this really great, and I think they still are to some degree, but like this really great paragon university in the disability community to some degree, because they did a lot with accessibility earlier than it was required, in part because California tends to have better requirements in general, I think, but they were always one school that I heard about as being really a great place to go if you had a disability. And so I think that, in terms of reasonable decision, other people can talk about, why it might be reasonable financially or not, but they definitely harmed their standing with the disability rights community and the disability community, I think, in doing this. There was a lot of people who felt that this was a bit of a slap in the face from a school that had always been seen as being very supportive and a partner with people who had disabilities, to just suddenly say, well, we're not even going to come up with a plan to slowly release stuff or to release some stuff. It's just more like we're going to pack up our stuff and go home because we don't want to go and make it accessible. And I think that was disappointing to a lot of people.
Sure. Now, I'm not promoting what they're going to say, but allow me to play devil's advocate for just a moment. Certainly to retroactively go back and caption all that content they had created. Now, they should have done it from the start. I totally agree, if they were a leader in this field. There were, and we all know, there's substantial budget deficits. They were a state university, shrinking state's financial support. They had an obligation to put their money where they thought it could do the most good, and I guess they just didn't think that this freely available stuff. Now, this is the difference. You're on campus there and you're taking a class with Berkeley. They're captioning that. They have to, right? Otherwise, so this was stuff that was out in the world. In fact, the complaint emerged from people that were taking their free online classes.
Yeah, I think they're MOOCs, right?
Yeah, they were like their MOOCs, classic. So they just thought the expense to retroactively do all that was too much for the university to handle. And so I heard the intellectual property aspect of it, but I also heard the fiscal idea, which was the ultimate, decider of, as you point out, I'm taking my ball and I'm going home. But again, that's a shame, because there's a lot of software and technology out there that's much cheaper, less expensive, that could do some of this work. It's not like it's hand-coded like it was in the past.
And, I mean, I think I would have been more sympathetic if they said, okay, we're right now gonna take everything down and here's our plan for re-releasing some of it, or
Sure, sure.
we're gonna take down X% and here are some things we thought were key. But they really just sort of were like, okay, we're done here, it seemed.
So, I mean, a couple of, I guess, key elements about this, right? Like one, you know, this really puts into play this kind of, on the one hand, a trend towards open education, making your content available online. And two, you know, that you actually do have to build in accessibility as you're going through. So you can't just like throw stuff up online and say whatever. You actually have to like throw stuff up online with a little bit of a plan and some thoughtfulness, right? So basically they're saying if you're putting this stuff up online, it does have to be accessible. The second thing that really came out of this, I think, is that they're saying that the really automatically generated YouTube sort of captions is not adequate, right? So those you can throw up, and you might think, well, all right, I'll do that, right? But the thing is, like, that's just not going, that might get you part of the way there, but you do have to have somebody going back through there, because those are, at least at this point, they're really kind of bad, right? And so that was another key piece of this. So, you know, I mean, I sympathize with the budget concerns, but I think I'm with Carly on this question, which is...
Okay, I'm not against it.
Kyle is the bad guy here, let's just be really clear. I mean, I think they really should have considered a plan, right? And to kind of maintain their stake both in open ed and in accessibility, and, you know, like really been a little bit more progressive about their thinking about this. I think what it means for all of us, right, is the DOJ is not necessarily pushing these kinds of matters anymore under the current administration. But what it means, that doesn't mean that we get off scot-free, right? That means that we actually need to look at what happened with Berkeley and say, oh, we really need to be building in universal accessibility like right now as we're thinking about, as we're moving ahead. And, you know, before the retroactive digitized pile gets even bigger, right? So we need to be like looking at our workflows like right now and thinking about what we can do to sort of do that. And then also looking at the stash of stuff we've already done and thinking about like how can we start making inroads into doing that. Because the key piece is honestly to have a plan in place, right? A plan to respond when you're asked, and a plan to sort of like go back and look, you know, and kind of build everything to where it should be. So
Yeah, otherwise you just have a streaming media, you know, wasteland for anyone that has disability and stuff like that.
Can I ask a question about this?
Sure.
So, I'm not going to weigh in on reasonableness, because,
That's for the courts to do.
yeah. I guess one of the things that I've been thinking about as I've been dealing with this throughout my career and working at different institutions, both public and private, has been a concern. You know, I became a librarian because I wanted to provide access to all content. And so this concept of we should not even purchase content or acquire and make accessible any content unless it's accessible. I don't want to say it gets censorship-y sounding, but I have heard some of that language before from people who may not have that experience. You know, a three-dimensional object that's reality, sure, we can try and recontextualize that, but I'm concerned that a library will just say, no, it's too risky because it's not accessible. So I sort of, I'm fascinated by this. I'm sorry that I was, you know, asleep when I heard about this Berkeley thing, because I think it is, you know, and there are people in the ether who, at a humongous institution, who make these sort of workflow decisions. But I am concerned about the downside too. I mean, less accessibility, pulling all of those materials off, now nobody gets it, you know, now nobody gets anything, sort of. It's like, well, if you can't figure it out, then nobody gets to play this sort of thing. That doesn't seem like necessarily a good solution either. So maybe as you continue your talk, you'll speak to some of these solutions too.
I think part of it is just building it in from when you start, so maybe there are things that, as long as you work it into your budget, then you can buy maybe slightly fewer things, but make those accessible to everyone, rather than creating a scenario where you have sort of a dual level where students with disabilities have one level of access and students without disabilities have a greater level of access.
I like what you're saying here, and actually, there was a settled case with CNN. They didn't close caption news, and they defended it on free speech First Amendment grounds, saying they had a.
And that's exactly where I'm
They made an
getting a little
editorial,
bit
they made an
nervous, yeah.
editorial choice not to caption the news, and they won. But it was under this California anti-SLAPP statute, which is supposed to prevent frivolous lawsuits. It was a really weird decision, but a lot of people were like, they made this decision to not do this for reasons that associated with news reporting. It's a bizarre decision. We don't cover it because it's so weird, I can't get into the weeds on it. But we've seen that rise up, that speech, First
Well,
Amendment element before.
And we've got a lot of interesting, some of us have just analyzed our 16 millimeter as part of the VLC, and I don't think any of that has captions on it.
Sure, no,
Unique
it won't,
content.
yeah.
So do we just say, well, we don't want to deal with it because it doesn't have captions? We'll deal with the easier material that's captioned and more readily available.
Sure, or easily captioned.
Yes.
You know, more
Yeah.
digital formats with software can do it for you.
I'm not sure that that's a problem though, right? Like, I mean, we do have to think about these factors. I don't think anyone is saying this is, don't ever buy things without captioning. What I would say is, actually put into your purchasing agreement that they will caption it when you need it, or that they have a plan, right? So I don't think people are saying like there's a black and white rule here. People are saying actually like start thinking about this and start making plans and understand the territory, right? That's what you're all doing here. You're sitting here to kind of understand the lay of the land. But you know, it's kind of easy to think of it in this kind of knee-jerk, like, oh my God, like, you know, stuff is down, that's bad. And I agree that it's bad that the stuff is down, but I think that the binary of like up and not accessible or down, that was a false binary, right? And so I think, you know, that's what we need to be thinking about here. Like, what are the reasonable approaches? Like, what is the reasonable way to start getting stuff accessible? And it's not just because there are like whiny blind people, right? It's because the accessible stuff ultimately is actually helpful to everybody, right? The blind people, the print impaired, people who are doing text and data mining, people, you know, it ends up being useful to everybody, right? Like that's the classic curb cut example, right? Is that like, oh, we're doing curb cuts for people with wheelchairs, but it turns out to be really inordinately helpful for actually all sorts of people and just makes things universally more accessible for everybody. So when you're making an investment in accessibility, it's not just an investment in a small subset of people, it's like actually getting the full value out of that particular content. And so that's one of the things you need to be thinking about when you are acquiring content. Are we going to be able to get the full value out of it, right? Or are we going to have to spend extra money to get the full value out of it, right? Or is it, you know, it's already there, and then you can compare that with some other piece of content, right? We do have to make these choices. So yeah, there's a...
So in the case that Laura's talking about, this is content that we already own, physically own. It has the 60 millimeter films that are gathering dust somewhere. Does it meet the accessibility legal requirements to post this up there and say, we will make this accessible if you need us to do so? Because that's what we do with our print books. It's not like we've scanned them
Yeah,
all.
so the law isn't like make everything, the law asks for the more narrow, right? If somebody says, I need this, you have to provide it, right?
Mhm.
But if it's a public place of accommodation or something that's a little bit broader, it should already be done in some cases. So it depends on if you're looking at Title II, if you're looking at Title III, if you're looking at a particular state code. So they handle it differently. It's just easier to make broad access instead of having to piecemeal do it.
Mhm.
But again, this is where the copyright concerns come in, right? I would like to scan every book in my library and make it fully accessible. But sometimes, you know, they're like, well, why? You have no blind or print disabled students this semester that need this. So, you know, maybe that's counter to what they're doing. Please.
So I'm not 100% sure of this, but isn't a lot of the, or hasn't it been a lot, in a lot of the lawsuits, particularly around coursework, that it's about the timeliness of providing that?
That's also
Because,
important, yes.
I mean, I know that at our institution, things aren't done the way that I would like them to have been done.
I think everyone can agree here
You
with
know,
that.
I think everybody can agree with that, it doesn't work exactly how we'd like it to, but I think that, you know, when there's a need, it happens, and it gets made happen, you know, it happens for the student.
Sure.
But it's.
That's a
little
best
different
practice, of
scenario.
course,
Yeah,
as
it's best
well.
practice, but it is sort of like reactionary, not proactive.
It's not proactive, and
And
we
that-
always talk about that.
That was an important factor in that first UC Berkeley case that we
Right.
alluded to. A big part of that was that they felt that they weren't able to turn it around fast enough. And
Right,
that was part of why they said they had to hire an additional position and change, and went into some detail about their workflows and how fast and how accurate things had to be because there were concerns about that delay.
But it's important to distinguish, I think, between, you know, the hard copy stuff and the internal users, right?
Right.
That's the stuff that, like, if you're signing a book to a student, right? And you've got to make that book available accessibly, right, to that student. And that might mean scanning in the hard copy. That would be like Office of Disability Services or something like that. You've got to have, you know, your internal operations have to be, you know, one particular way, and there has to be turnaround time. When you're setting up a website and just making stuff generally available to the public, right, you don't have to go back and digitize your hard copy materials, right, to put it online for the public. But if you are putting stuff online for the public, what's the time when they need it? It's like, you know, it's like then, right? Like that's when they're encountering it, and they need to be encountering it on the same terms as you know, any member of the public needs to be able to access it on the same terms. Does that make sense?
yeah, no, I agree, I just, it was, no, I agree.
All right, so we have, are there other legal specific cases that we should look at that release to websites and mobile applications? The first one, which I didn't put in my slideshow, was foolish of me, was Netflix. Does everyone know that Netflix was sued over closed captioning streaming media services? Does everyone remember what happened to Netflix? Well, they settled, like most cases in this. Netflix agreed in 2014 that or 2012, by 2014, they will have full captioning of all of their shows. Now, that was a major, major win for streaming accessibility. That was a huge deal. They frankly admitted, yeah, we should have been doing this. And we will dedicate time and resources to make sure this gets done. And the rate at which Netflix shows are popping up now, I'm not even sure how they're doing it so fast, but.
And as somebody
I
who
mean,
hears just fine, I love it. I
Yeah.
watch closed captioning all the time, you can have it on more quietly, it's great.
Yeah, so I think that was one of the more important cases, but more recently we've seen some stuff that I think, you know, and obviously Netflix is a commercial entity and, you know, we're libraries, but the two that I brought up to share with you today is about pizza. One was about pizza, one was about speakers. So everyone, you know, have you seen that Domino's pizza ad where the kid's like doing stuff and he's tracking how his pizza's being made and his pizza's coming along and the pizza app is awesome. Unfortunately, all of that online ordering system did not allow users to complete purchases with screen reading software, JAWS or otherwise. And so the mobile app didn't let anyone that was blind be able to, you know, order pepperoni pizza. And it also prevented the use of voiceover software, which is good, and it was generally not in compliance. So we're thinking, oh, you know, forget it, they're done. But this is what's kind of funny is that the case was dismissed, and it was not a violation of the ADA. Now this is kind of surprising, but this is a classic example of why regulations often fail the end user. So in order to come up with rules, according to the way the government posts comments, makes rules, etc. You have to have this notice of proposed rule making was made in July 2010, which basically says, hey, we're going to talk about what rules we should use to enforce for Title III entities. Now, Domino's Pizza would fall under that. The problem was they kept pushing back the fact that they were going to, like, we'll come up with these rules next year, another year go by, like, we swear we'll do it the year after. Continued. So because, you know, they should know, commercial entities and other places of public accommodation should know what the standard they're going to be held to. Well, the DOJ never clarified this. They didn't say, what are the obligations that ADA Title III has with respect to this website and many other websites? And so that's kind of the real problem here, is that you have no regulations, that a defendant doesn't have a reasonable opportunity to know what is prohibited, right? And therefore, technically, I call this a fair treatment violation, but due process. This is against due process. You can't be held to standards that don't exist. And so this is very much falls on the DOJ and the fact that they put off this accessibility discussion and rulemaking procedure for a number of years. Now, the court could have still done something.
Well, and what I was gonna say is that I'm not convinced other courts wouldn't. So this is
Sure.
a lower court in,
This is.
I wanna say Florida,
Yes, it was.
and,
The Homeland of Dumb.
so, no, that's Michigan.
Oh, I'm sorry.
So they decided in a lower court in Florida, but I'm not convinced that that's something that someone in every state should rely on.
No, it just was really interesting because I had never seen the ADA thrown out. That was clearly a violation of the ADA. But again, this is, like, I don't know. I don't know if I need regulations to understand that you should probably let the stuff be able to be read by a screen reader and print vision disabled. So that was a bad one. The other, oh
Sorry,
please.
I was going to say, what's interesting to me, though, is exactly what you were saying about how far this went. I mean, this was pretty egregious. It's hard to imagine what the regulations would be that wouldn't cover
That wouldn't cover
some of
this,
these
yeah.
problems. It wasn't that there was some very technical issue that someone was having.
No.
It was pretty major, so it did suggest that at least in this jurisdiction.
And the Domino's, prior to having this fancy app and tracking your pizza, you could do it on both websites.
Right.
You know, with the basic HTML. So, you know, they were like, well, you know, our app is innovative in some capacity. The other
Well,
one is, oh, so please.
From a technical side, it's interesting too because they could have easily left access to both.
Of course
A lot
they
of
could.
websites will have, I think maybe SpringShare products actually still do this, where they
They
have
do.
like this, a specific link that takes you to a screen reader version
Yep.
for sections that aren't as accessible. Like I think LibCal might still have that.
The other one is a speaker store case, which is Gomez. So a legally blind citizen tried to use a website, browse and research audio equipment. Again, same kind of situation with Domino's. It wasn't compatible with the JAWS screen reader he was using or any other software at all. So the defendant said, hey, well, you know what? Guess what? Our website where we spell seekers is not a place of public accommodation under Title III. And a lot of people are like, ha, of course it is. And again, same kind of thing. This court said the ADA's reach is limited to physical, concrete places of public accommodation or anything that affects access to or enjoyment of the physical spaces. And they actually said, this court actually said that the website was wholly unconnected to the store, which seems a little bizarre. I mean, you know, you can go to bestbuy.com or you can walk into a Best Buy. Well, those are limited now, aren't they?
If you can find
If you can find one. But they said that the court found through the testimony of the blind citizen that they never intended to utilize the physical retail location. So therefore, this was detached, like the web existed in the web and otherwise. Now, this is on appeal, but what I always pointed out in this one is that ADA does not require public accommodation to create full-service websites for persons with disabilities. This could be libraries. I mean, it could be, you know, in many sense. And then it does not require a place of public accommodation to have a website at all. That's a really harsh reading of the law. Now, there's a split in the circuits about this. Not every part of the country agrees with this one. I believe this was the third circuit.
Well, and also it's an interesting reading because my response to the second point there about does not require a place of public accommodation to have a website is that they opted to have a website. I mean, it doesn't require you to be a place of public accommodation either.
Right.
They could be an invite-only store if they wanted. But it seems like by putting a website out there,
You're making
you're
yourself.
making your
yeah.
choice.
And the
So-
fact that they would consider that the business is wholly disconnected.
Yeah.
Because the blind citizen didn't want to go to the store, so now they're held to a different standard, and that's insane. I don't want to go to half the stores, that's why I order on Amazon. But it's that concept there that they're kind of splitting hairs here. And this is the dangerous aspect of the courts now. I use a guy named Colonel Silly in my teaching, who's from Monty Python. If you ever heard it, he interrupts the sketches every single time. He's like, this is silly, this sketch is terrible, and move on. In this particular case, the court, in a footnote, said, you know, the internet is an integral part of modern society. This is 2018, people. How is that a footnote? That should be the main thrust of the thing. But what they didn't want to do is, and it depends on where you are on the political spectrum on this, is have activist judges that would make law, right? They said, hey, this is up to Congress. They want to define a website as a place of public accommodation. They need to amend the ADA to do that. We here are the judiciary, and we're not supposed to do this. We're not supposed to make law, which I find to be frustrating and silly. Silly indeed, because I get what they're saying here in that, oh, well, the ADA didn't plan this. But again, as I pointed out in the very beginning, the ADA was written in 1990, the World Wide Web was 1991. There was no possible way that they could have foreseen where this goes. And it's up to judicial rulings to make this statute extend into modern life. That's just a problem with the law. I don't know. Yeah, please, Laura.
I was just gonna say, I mean, the weak link, you know, for these cases, so it is a circuit split. It is, I think it's very likely to go to the Supreme Court before
I
it
hope
goes
so.
back to Congress, right? But I mean, the weak link here is, you know, this idea that like it's a standalone website versus something that's like connected to an integral with like the business, right, or the operation. And so defining that is obviously hard and silly, right, and really tricky. And you know, you might say, well, okay, I'm going to just set up a special website for this exhibition, right? But you've got the print materials, right, in your collection. Or I'm going to set up, you know, a special website that doesn't have anything to do with my services. I would, if I were counseling somebody, you know, as an attorney, I would find it very problematic and concerning about how to make that distinction. I would just think it's much safer to say, like, your website is connected to your services, because I don't see any clear standard for deciding when it's not, you know. I think in some of these cases, the courts are trying to knock out plaintiffs that they see as bad actors, right? You know, so you've got, you know, activist plaintiffs going around and basically just trying to, you know, hit a lot of entities, and either for attorney's fees or out of the doing justice kind of mode, however you see it, right? But I think there's been some pushback against, you know, that kind of plaintiff, and I think that's resulting in some weird case law. But I don't think it is, you know, if you're looking for ways to like cut back on your accessibility budget, like I really wouldn't rely on this. I would be worried about that,
Just,
this trend.
Absolutely. When do we have Phil, by the way?
Oh, basically now. I think we have, you know, we have about 10 minutes for questions. I mean, like,
Sure,
I don't know how many
absolutely.
more slides you have, but.
No, we just had 2 questions. We just had,
Yeah.
on a more practical side, if you do not own copyright to a film and want to caption it, what are your options?
Your favorite phrase.
Yeah,
How are you?
yeah, I mean,
Actually,
so
120.
clearly we have the Chafee Amendment, we have the Title 2 and 3 of the ADA, we have the IDEA, we have all these reasons. Just do it. Like, does anyone disagree with that on this panel? Do not fear this type of stuff. Please, go ahead.
So if Marrakesh doesn't pass, will that include foreign films?
I don't think so. So, foreign films that are bought legally in this country,
I think.
as
I
long as
think
you're
it's
starting
fine.
with a legally authorized copy,
Yeah.
generally you're in the clear, right? It's the pirated copies that I would be concerned about.
I mean, I guess I might advise people to do it, if it's only for a class, just do it for internal use, because that strengthens the fair use
Sure.
argument, rather than like posting it to your YouTube channel. But that's probably the case for other reasons to do with the video itself, too.
Yeah, absolutely. I tend not to think that we should caption it and put it on YouTube. I mean,
Yeah.
YouTube is supposed to the world.
I wouldn't put the video on YouTube, but I would save that caption file and,
Sure.
and upload that and share that freely, right? And so
Absolutely.
that other people, and you know, so all the little the file and the technical connections to make the captioning sync up with the video. Like, I mean, save that and reuse it, but you know, you don't want to redistribute the film. I don't think there would be a real difference between, you know, whether it's a foreign film or a domestic film, right? Like that would be, for copyright purposes, they all get national treatment. And so for copyright purposes, we have 121 and 107, and we have those exceptions. And if we get Marrakesh, we do. Just because the Marrakesh is an international treaty, it's not going to create more distinctions between foreign and domestic films.
Yeah, I think it just gives us another arrow in the quiver of useful things that we can do.
Yeah.
and like that. The last one, sorry, is as library collections are more and more focused on licensed electronic resources, what should we be looking for in a contract on licensed resources to ensure accessibility? You kind of alluded to put any type of captioning on the vendor. I think that's certainly an interesting thing to say, like, hey, we're a fully compliant ADA Title II, Title III public place of accommodation. If we're going to do business with you, you have to give us this with captions if at all possible.
And if you're a state, you're a public entity in Massachusetts, right?
Yes.
Like there's state procurement laws as well, so kind of like add to that, set of requirements. So if your council is not bouncing contracts, because they're not, providing sufficient accessibility, they might want to start thinking about that, right? Because Massachusetts procurement law, is going to be requiring as well that state agencies make things accessible. So it's not extremely, I guess, crystal clear. The guidance isn't completely out there, but I think that's the soundest reading, yeah.
You're saying by state, you're saying public only.
Public, yeah, so yeah, the state procurement rules for public entities. And then, for private, you're still dealing with federal, right? Everybody's dealing with the federal.
And if you're looking for models, a couple places to look would be, the Big Ten put out a website recently where they have a model provision, as I recall, but they've also done some really interesting work where they had, I think, a consultant go through and do accessibility testing on a lot of the vendor products, and then they allowed the vendors to write responses if they wanted to, and they've been posting those publicly. So that's a good place to go if you're curious in doing your collection development. And Michigan State University, they have thought a lot about, I think, this stuff, and they have a lot of documentation on their website about their accessibility services, some of which talks about how it fits into their collection development.
Yeah, very.
And both of those are publicly available on the web, so I would recommend.
What's the big?
It's a consortium in the
I don't
Midwest.
remember what all schools are, but it's like major, mostly I think state, but I could be wrong.
Yeah, I think it's
Generally good sportsman.
I was just like,
I did a double
law.
take, like you just said. Carly has never come to a basketball game with me, ever.
I never said the word Big Ten until I started posting accessibility stuff, and now it's like all about Big
It's
Ten.
fantastic, it really is.
But this is an
Yeah.
But in your contract negotiations, this is an opportunity to really push back on vendors, and I don't know if Gabe is waving his hand at me or giving me a 5 minute.
No, I have a question too.
Okay. All right.
Because you know how they're always trying to make us, indemnify them against this or that or the other, and we're always like, no. You could try, right, to make them indemnify you against, accessibility related claims, right? That would actually give them some incentive to actually start making sure that they're accessible, right? I don't know if anybody who's gotten that.
No, but it's a
language,
great,
but
it's a great
it's
strategy.
It's a nice strategy, right?
Nothing's
You can-
finalized till they sign it. So
Yeah,
you
but
go back
basically
and
you want
forth.
them to promise to do it, you would like them to
Best efforts.
create a timetable, and so you want to basically put those kinds of obligations, just like one more little string in terms of what you're getting from them.
And I would say maybe identify a specific department or person that you can contact if there's something that someone is saying is not, because I think a lot of times it can be hard to get in touch and get them to do it in a timely fashion.
Okay. Sorry.
Have you seen any success with this contract negotiation? And if so, does that success seem to be extending to future contracts that don't necessarily have that provision? So once they're adding the captioning, are they giving it to everyone?